Welcome to Working Smarter, Concise Compliance Conversations featuring Wendy Rubis, sponsored by Village MD, primary care physicians, practice medicine the way you've always wanted, data, resources, and clinical decision support to care for your patients inside and outside the exam room.
Hi, welcome to Working Smarter. I'm Wendy Rubis, General Counsel of Village MD. And today I'm so excited to welcome two special guests. We have Linda Wawzenski. She's the Deputy Chief Civil Division of the U.S. Attorney's Office in Chicago. Everybody knows Linda Wawzenski, okay? And we have Lisa Noller, who is a friend of mine, and she's also Big Shot Chair. Big Shot's not actually in the title, but I added that. Chair of the JEDI, which is Government Enforcement Defense Investigations at Foley Lardner, a renowned expert in these areas. And today, we're so happy to have both of you here to talk to us about the enforcement environment. Welcome.
Thank you.
Thank you.
I have to admit, I'm a little nervous because I have so much respect for both of you. And we work so hard to really educate our listeners. And our goal is to help our listeners be smarter. So we're so happy to have you here just to share your perspectives. So let's just go ahead and get started. So one of the things we know at Village and really every compliance program is we know that a lot of things get identified through whistleblowers. But recently, I think we've heard we're seeing activity in other ways. You know, we get reports and things that show how many of these cases were whistleblowers, how many were identified in other ways. So we're just wondering, are you seeing changes in that balance and that volume there? And what do you think is behind that if you are?
Well, Wendy, you're right. The majority of our recoveries for many years has come from qui tam cases. And in fact, in fiscal year 20, just ended last September, 70% of the government's recoveries came from qui tams. But as you point out, there are other ways that we get cases, and especially in the healthcare fraud arena, probably the most significant way in the last decade that we've developed cases on our own has been through some very sophisticated data mining. We do a lot of data mining, and the Department of Justice has contracts with people who do very sophisticated data mining. And in fact, a lot of times we get information about our newly filed qui tam cases where the justice contractor who does this work will bring us information to let us know whether or not the allegations are borne out by the data mining that they can do, both with Medicare and Medicaid data. So that's a sea change, because I've been doing this work now for probably close to 30 years, and nobody ever did any kind of data mining. We didn't even have access to a lot of the Medicare data, which for about 15 years, we have access to Medicare data on our desktops in the office. It's unaudited data, but it still can give you a snapshot of claims and payments and, whether or not there's something there. So just like in many other ways that data mining has become an important factor in many businesses, it is a very important method for us to find providers and interactions between providers with fraud, because the level of sophistication of this data mining is such that we can find connections between providers and institutions that might be committing fraud.
So you have obviously access to data that's not always publicly available as well.
Correct. Yes.
Even I have to just totally agree with you. I mean, I remember when, what is that expression? I'm young enough to remember when a first warning somebody would get would be a 5-record chart audit. And then it would be like, you did this wrong for 20 years. Today, it's a lot more real-time feedback, and it's just a lot more sophisticated because of the data. And I think hopefully it's happening on our side too. We're more sophisticated. We're looking at our own data and identifying outliers, but very interesting that that's actually a new source of initiation of investigations. And I certainly did not know you guys have such easy access to it at your desktop. That's fascinating.
Right, we do.
Wendy, what's interesting, our client got a CID and we're representing them, and it just came in a couple of weeks ago.
For our listeners, that means civil investigative demand. If you are a Village MD workforce member and you get one of those, please call me immediately. Just had to say that.
So one of the questions asks us to explain why this particular entity is an outlier in a particular area of billing.
So they asked you to explain. So that would be like they're asking me, why are you an outlier?
Yeah.
Right. And that's the kind of information that we get from this data mining. We will be told that this person is an outlier, or we'll be told that this person is the number one biller in the state of Illinois, or we've even had a case that we had once in Chicago where this particular physician was the number one biller in the nation under a particular code. So that's extremely valuable.
I used to do a slide in training for physicians and say, go look up at yourself. This is not a place to be the best, okay? Don't be the top biller. But in our case, and just for those of people listening, it's like we have a process where we identify outliers. That doesn't mean they're wrong. Then we go validate. Okay, you're high. Yeah, you have complex patients. Or yes, you're located near it. So, but I've never been asked to explain. That's almost like, you're high. Do you know for sure those are right? That's fascinating.
Well, but I'm actually thrilled that we got the question, right? Because it reminds us in putting together.
By the way, we're not usually thrilled. Thrilled is not the word I put with the CID, okay? But I know what you mean.
Right. We have the CID. So I welcome the opportunity. I mean, the government is basically saying, we already know that you're an outlier, right? Deal with it. Those are facts. Now they are basically saying to us, that may or may not be a problem. You tell us why you think you're not an outlier.
I can give you an example. I mean, one of the things here in Chicago, we have so many teaching hospitals that we are likely that we're going to have a lot of outliers in certain specialties where somebody might be the best person in the country for a particular procedure. And so we take that kind of stuff into account because being an outlier doesn't necessarily mean you're bad. It might mean that you're just very good at some particular aspect of procedure that only you perform or only 3 or 4 people in the country perform.
Yeah. But to think it's actually changing the balance of whistleblowers I agree, it's a major change. The thing I worry about is that sometimes, whistleblowers aren't always right. And there are limitations in some ways as to that process. So what are the ways that the parameters that are used to manage these risks when they happen?
So fun fact is that Linda was my very first supervisor in the office and actually taught me how to bring qui tam cases and is a totally respected colleague, 25 years later. So I'd like to think that she actually taught me some of this stuff, even though we are now on opposite sides. But one thing that she taught me that I try really hard to teach my clients is that whether you believe the whistleblower or not is completely irrelevant. Frankly, under the False Claims Act, the whistleblower can be part of the fraud that he or she is alleging, right? So piece one to sort of limiting and managing whistleblowers from the defense side is actually listening to what they have to say, treating it like an opportunity, and conducting an investigation into what their complaints are. Sometimes they're completely unfounded, Wendy, totally agree with you. Sometimes they're onto something and they don't know what it is, in which case you definitely want to address it before they drop a dime to Linda's office. And sometimes it actually is something and you've got an obligation to see it through and self-disclose, right?
Yeah.
So that's on the front end. On the back end, once you're faced with a civil investigative demand or, God forbid, a qui tam lawsuit, there's a lot of arguments that the defense has in its arsenal that DOJ does listen to before they decide whether or not they're going to take the case on.
Yeah. No, I'm interested in this. Do tell.
Well, I don't want to make this overly legal, especially given the audience here, but, basically, not every statement is a false statement. Not every false statement matters to the government. And even in the realm of false statements that do matter, to your earlier point, they're not always what they seem.
Yeah.
So before the government makes a decision whether or not to bring a case, we always try and work with them to give them what, the information they've requested, but also taking the opportunity to go in and say, here's what we're seeing, and then have a dialogue about it. Because a lot of times we can say to them, look, this statement that you're super concerned about is not false because it's subject to reasonable interpretation. The guidelines are changing. It used to be false, but it's no longer false because of a change in regulations, et cetera. And so, our biggest way to sort of rein in the DOJ is to say, we know you're super busy. We've also taken a look at this. Let's talk about what's really going on.
Yeah. That's interesting and so helpful. And yes, we worry that someone has a misunderstanding and they don't feel heard. My observation many times, there's people that don't feel heard. Are you seeing, Lisa? I feel like lately the published cases, I don't see activity you guys see, but I feel like I'm seeing more and more physician whistleblowers. And I feel like a lot more out of the compliance department itself.
100%. And in addition, the law firms that are taking their cases are better at this work. So again, go back 20 years ago, it was largely employment counsel who were dabbling in qui tams. There are now law firms that do nothing but this work. And so they have the luxury of only taking cases with sophisticated, credible whistleblowers.
Yeah.
One of the things that may be of some consolation to your audience, Wendy, is that generally speaking, nationally, the rate of intervention in a qui tam case, which means the government says, yes, there's fraud and let's either settle it or litigate it, is about 1 in 5. So that gives you an idea of the kind of vetting that's done. Now, that can vary from office to office and from type of case to type of case, but generally that's about the size of it.
Is that based on merit or is that based on bandwidth? Is that like 1 in 5 we think is meritorious, or we don't have enough people to deal with all this?
That can vary too from office to office because, there are some districts in which judges simply don't give the government enough time to do the investigation while the case is under seal to come to a conclusion, in which case the case is forced to be unsealed before we can say, yes, there isn't, or no, there isn't fraud. We don't have that problem in Chicago for the most part. So it's a little easier for us because we're typically able to actually make that decision one way or the other of a thumbs up or thumbs down. But it varies from place to place. And that can be frustrating, as you can imagine, for the DOJ lawyers, because then it's up to the whistleblower to go forward with the case without us.
Mm-hmm. Interesting. Okay, so one of the things we look at, and we've talked many times on our podcast about, and we love to follow these, is we have these dramatic takedowns. A lot of times they're in April. This year it was later, it was in the fall. The first thing we do is we go, who was it? Where were they? From my observation, it looks like it's a way of expressing priorities. So this year there was a lot of COVID and telemedicine and things, but I actually don't know, how are these priorities set? What is there for us to learn?
So I'll speak to it from the criminal perspective, which is the other side of the house from what Linda works on. Most of these are criminal cases, and they're exactly what you're interpreting them to be, right? They are a message to a discrete portion of the healthcare industry. We are watching you, and we are literally going to take you down, right? The word is selected, I think, for a reason. They are largely the product of strike force investigations. So it's a lot of, this is my word, and Linda may disagree with it, but it's a lot of low-hanging fruit, right? So it's the folks where you can literally get a pattern and practice in a discrete period of time in an area where the government has devoted resources and funded bodies on the ground who are literally looking at, for example, the opioid crisis, or Operation Brace Yourself last year was the October takedown, which was a bunch of overprescribed DME, where you literally had, beneficiaries with like 3 knee braces when you only have 2 knees, right? What we have been able to track just from the defense side, because I don't set the priorities, just to be clear, I wish I did, but nobody's asking me to, is you look at the OIG work plan every year, and that list of priorities is roughly around the same number every year. And it's not 100% correlating with the takedowns, but there's sufficient overlap. And one thing to your COVID point, Wendy, telehealth has just expanded, exponentially this year. And we've already seen subpoenas to marketing groups, providers who are using telehealth, physicians who have contracts with telehealth agencies. And so I think that's the next big boom. And I guess what I would say to folks is it is impossible for the government to know on the front end whether there is a valid and existing physician-patient relationship in a lot of these instances. And as soon as they see marketing company, they think kickback. And sometimes that is a valid conclusion to reach. Sometimes it's not because of the arrangement. So my guess in reading the tea leaves is that's going to be keeping the government busy for a few years anyway.
Well, to your point about low hanging fruit, what we saw, and I think you said it was October, I knew it was the fall. And it was like, okay, you build so many visits, it's more hours than it's in a day. Okay. Things like that. Okay. I mean, there's only so much you can do to help someone who does that. Okay. But so low hanging fruit, but definitely we know telemedicine proliferated. We know there's concern it might be easier to abuse. We've done a lot of work on our end just to make sure we're clear on clinically what's valuable, when is it appropriate, as well as what are the rules. But I think you're probably right. We're going to see more there.
And state by state, by the way, one thing that we've been running into is that there have been these emergency exceptions to some of the state regulatory schemes to allow for telehealth. And so there's been, a lot of the practitioners don't know exactly, if you practice in, for example, Illinois and Missouri, which paradigm do you follow? Why? How? So honestly, I would tell everybody that if they have any questions about that, to talk to your team on the front end from a general counsel compliance perspective, because the worst thing you can do is guess and get it wrong and find yourself caught up in the next takedown.
Oh yeah, we have all kinds of controls. Yeah, they know to call. But if they're not Village MD, they should call their own lawyer. If you're listening from Village MD, you should call me. But we have so many different pre-bill confirmations and things like that on those. Okay, so Linda, you said something, and I have to admit, so I think I get confused, civil and criminal. Is that right to say it's only an indictment if it's criminal? Because there goes my unboxing indictments episodes.
Well, yes, an indictment is criminal, although there is a criminal complaint also. On the civil side, it is only a complaint if it is actually filed. So that's really the difference.
So if it's civil, how is it that the government is filing a civil? I don't understand that. I thought if it was the government, something out of your office is always criminal, but that's not true, I guess. It's just in the category of to be avoided. Again, no offense, but I guess that's confusing to me.
Yeah, well, we have a large civil division that does all kinds of civil litigation, and the False Claims Act is a civil treble damages statute. So what we would file is a civil case, just the way the Qui Tam lawsuit is a civil case. And the thing, though, is that there's a lot of coordination between civil and criminal, so we can actually get you both ways. We can indict you, but we can also file a civil suit against you for treble damages, because criminally, a criminal defendant will pay restitution to whoever the victim is of the fraud, but that's only singles. That's the amount of the loss. But on the civil side, we can collect up to 3 times the amount of the loss, plus a penalty for each individual false claim. So it's kind of like a 1-2 punch. And we coordinate all of this. Like, for example, every healthcare fraud Qui Tam case that comes into my office also goes down to the chief of criminal frauds for you to determine whether or not they want to assign a criminal AUSA to the case along with a civil AUSA, Assistant United States Attorney. And then they will work together as a team with agents from FBI, HHS OIG, and sometimes other agents, Office of Personnel Management, who takes care of government healthcare programs. We may have someone from the state for Medicaid. So it can be a large team that works on parallel tracks, and as the case goes on, makes decisions. Okay, who are the individuals that we can indict? Because it's much more fun to indict an individual who you can send to jail. But maybe the entity, maybe whoever that physician works for, is the one with the deep pocket that we can hit up for the treble damages.
I see. So is the main difference, if you're civil, you're not going to have jail. You might have fines. That's the main difference. But what you're telling us is just because you're with the civil division, don't take a rest, because it doesn't mean it couldn't evolve further depending on the facts. Not that anybody would, but yeah, okay. Now, the other thing that gets interesting with these self-disclosure protocols, this is confusing to a lot of people, is there's this HHS, the self-disclosure protocol. And I think that's evolved over time. But is that still like highly coordinated, or how does that work?
Oh, absolutely. We get a lot of self-disclosures in Chicago. I get self-disclosures from all sorts of entities and individuals all the time. And we have to coordinate those with the Office of Inspector General, because only they have the authority to allow us to continue forward and to make the determination that they concur that this is a good situation for a voluntary disclosure. And what we do is we follow the HHS OIG protocol, which limits the amount of exposure you can have for damages to double damages. And we get their sign off on the agreement that ultimately gets entered into if we decide that this is a good voluntary disclosure. And we can then give that entity a fraud release along with an administrative remedy release from the Office of HHS OIG. I always encourage people to do voluntary disclosures because you save time and money and legal fees, although not everybody might be happy about that. But because we will usually work with the voluntary disclosure entity and their lawyers to come up with an agreed audit protocol. They conduct the audit. If we review it and we agree with it, we come to an agreement on the amount of what the loss is and enter into agreement, and it's gone. And that fraud release that we give the entity who made the voluntary disclosure, I call it the get out of jail free card against a whistleblower. Once you've been released from having committed fraud for this conduct, there's nothing that a whistleblower can do with that.
Mm-hmm. Got it.
Just one word of caution. So I agree with 100% of what Linda said. And frankly, if I have a client in the Northern District of Illinois, I will bring it to Linda because her office treats them fairly and works with us on the audit scope and the scope of the release. I will say, though, that my experience is not consistent across the country, and not every U.S. Attorney's Office is as good at listening and working with the defense bar as the Chicago group. And same thing with HHS. It's a little bit of a roll of the dice. Sometimes you get an HHS lawyer who understands and appreciates that not every mistake is fraud. And sometimes there are some out there who think that, if you flushed the toilet wrong, you did it because you were intending to destroy evidence, right? There are different mindsets. We're all unique individuals, right? But there's a protocol and not everybody follows it the same way.
That's so interesting. Yeah, because when you take something in on your own and you're me, and I had to bring my organization, I do want some credit. Okay. I want a little point, something for bringing it, even though it is your duty, it is legally your duty to report yourself. But that's interesting. And I think that coordination has evolved somewhat over the years. So it's always good to kind of know how that's working. One thing we're looking at is VillageMD, we're on the journey from fee for service to value. And somewhere in between fee for service and risk, it gets weird because payment is about your clinical condition now, right? That's the same with DRGs. When you're getting paid based on someone's clinical condition, suddenly now you got different pressure on that diagnostic process. And I just think that is just a conundrum for all of us because the diagnosis should come from the physician. Yet, physicians, it's a 15-minute visit with a patient. These codes are complicated. So there's all these questions about like how much help can you give them and how, then you're dealing with like the coding industrial complex, I call it. You've got all these coders. But I just wondered, what are you expecting to see there? And what should we expect in terms of a trend?
Actually, one of my partners about 8 years ago at Foley Lardner came to me and said, you got to figure out how Medicare Advantage is going to fit into the False Claims Act world, because that is going to be the next dam to break. And it took a little while to catch up. But if you look at some of the bigger cases that have been filed in the last 3 years, a lot of them address the risk score, representations that the MA plans are making in order to get their capitated payment. And it is, frankly, the wild, wild west in some respects, because it's one of those situations, Wendy, where bundling the payment into a capitated payment under a Part C plan does not take away the fact that you're still certifying that everything that you did to earn that money needs to be in compliance with Medicare rules and regulations. But because of the cap payment structure, not every single little thing that you do that goes into that bid and the acceptance of the bid is actually even considered meaningfully by CMS. So it's a little bit of the wild, wild west. And I would say to everybody that, look, Part C and Part D are funded by the federal government in large part, right? So it's really no different from fee-for-service Medicare from a False Claims Act perspective. And while the mechanics of how this is going to play out from a loss perspective, so when people like Linda are trying to figure out what is the base loss amount,
that's where the calculation of the penalty gets weird, right?
Yeah, it does. Because if it's a false certification that is made to get payment, there could be a penalty attached to that. What is the thing that you are attaching the penalty to is something that courts, frankly, have struggled with. There was a case that came down last week. It was in the minority and women's business context, not healthcare fraud, but where the judge went through this really long analysis and said, look, just because I'm saying that I'm a good person doesn't mean that that matters for you to give me money. And so, the sine qua non of a False Claims Act case is the claim.
The suspicion is these payers just put a bunch of diagnosis codes on based on AI programs and things and didn't really make sure these diagnosis codes came from the doctors as part of their treatment. Of course, we have the advantage at Village where we are the doctors. And so that's a big part of our program. But I do see that. And just because the Medicare Advantage program is growing and it's huge and growing, it's successful and containing costs in many ways. So I think you're right, Lisa. I think we're going to continue to see that just based on the OIG work plan. Remember when the work plan was like once a year?
Right.
It used to be like once a year, printed out, the kind of thing Janessa does not understand. I would say print that for me, put it in a binder with some tabs. Now it's rolling all the time.
Yeah. The government's way more sophisticated than it was when we were kids.
So I've been reading that we should expect to see enforcement. Of course, we're seeing some things coming through. Enforcement on COVID. And as we said, COVID came, the lawyers were working harder than ever because there was waivers everywhere. We did a podcast called It's Raining Regs. And it was basically like thousands of legal proclamations and changes across states and the federal government and every agency. But now here comes like the enforcement. So what are you guys hearing and seeing there, and what should we expect to see?
Well, probably the biggest thing is last year, actually, Brian Miller was appointed the Special Inspector General for Pandemic Recovery. And so there is a whole separate bureaucracy set up that does nothing but investigate any kind of fraud arising under the CARES Act and all of the various different programs under the CARES Act. And now, maybe some of the audience might think that this doesn't apply to them, but take, for example, the Payroll Protection Act. I think many group practices and doctors applied for money under the payroll.
Yes, they did, because we did a webinar and we tried to help them figure out how to do it. Yep.
And one of the things that you have to remember is that everybody's got to retain their records about what they've done, because under the act, you have to retain those employees for at least 2 years.
Okay, good tip, Janessa. We got to remember to put that in our key takeaways.
Document how the money was spent. What were the internal controls? All of that kind of stuff. The same thing for some of the SBA loans that were pushed out at that time period. So, and one of the interesting things, there was just a press release at the end of March that the Department of Justice put out on this. As of the end of March, 500 individuals were charged with various types of criminal fraud under the CARES Act. I mean, that's just an extraordinary number in a relatively short period of time. And there were 120 of those charged that involved the PPP fraud, and including some doctors. And just today, I saw a press release announcing that a Colorado doctor had been charged criminally from taking $300,000 from 3 different CARES Act programs. So criminal indictment for this. This is a high priority for the government because there was so much money that was going out so quickly with not a lot of the usual kinds of controls that one would expect under this kind of program.
Unprecedented. And it was so vague, yes, too, because they would be all the time. I'm like, listen, this is not in this rule. Okay. It's basically pass, apply. We're going to figure this out. But many of our providers were trying to stay open. What do you think was the trigger where they go, let me go look at him?
Well, I don't know what the trigger is. Sometimes it's somebody that rats them out. I mean, I know there was a woman in Illinois, not a healthcare provider, but she had applied for money claiming that, she wanted to have this for her employees of her restaurant. Well, her restaurant had closed 6 months before the pandemic hit. And she used the money to pay off her credit card bill, all sorts of things like that. So, there are ways that the government has of figuring out.
Right. That would not be that hard to determine. Yes.
Also, like I say, finding people who come forward and say, wait a minute, this is not right. So just the fact that they've been able to indict that many people over such a short space of time gives you an idea.
Tells you the Wild West moment that we had.
Yeah, it's a huge priority. And like I say, to protect yourself against the possibility of coming under our purview or having a whistleblower claim that, record keeping and documentation of everything about how you applied for the money, how you qualified for it, what you did with the money, and why it met all of those regulations will save you at the end of the day.
I guess I would also add this, which is that that's just a good practice generally. So one issue we have, this is not the question, but in anti-kickback cases is, as you know, if one purpose of a payment to a referral source is to induce a referral, then you've run afoul of the anti-kickback statute. But a lot of times there are no purposes and 55 business reasons, but nobody ever wrote them down. And so I frankly don't fault the government for coming back later and saying, I'm sorry, why did you take that money? Why did you make that payment? If you can show that at the time that you were considering the action that you were taking, and it was 100% for a lawful, legitimate business purpose, or in the case of COVID, that you qualified for the CARES Act funds or that you qualified for the PPP loan, then it's not immunity, but you can sit down with somebody like Linda and say, look what I did and why I did it. And she will listen to that.
Yeah. I think there's this unspoken overlay as well that you needed it and it was relevant to the pandemic, right? I mean, that you didn't just gorge. Maybe that's not in the rules themselves, but it seems to me that that was the guidance we were giving at that time. And it's you had to be reasonable and just sort of common sense about it as well.
Yeah, but you should be able to document that, right? So here's the other thing is that there's a long statute of limitations on these cases, right? So, if you think about a whistleblower, they file a lawsuit, they've got they can file it frankly whenever they want. Say 2 years from now, they're upset at their employer and they say the physician that I worked for took CARES Act funding he should not have taken. So you're already 2 years down the line. Now the government's going to investigate that case for up to 2 years. And then it's going to go to trial, God knows how long after that, particularly with the courts being closed.
Nobody is going to remember except for in the legal department. In fact, I was just joking today. I go, we're the librarians, we're the historians, we're writing down intent, we're writing down the business. Like Janessa has heard me say a million times, with a commercial reason. We have a database, we have a field for it. This is our commercial reason. And people think we're crazy, but that's exactly right. That's what we're doing, which is because nobody will remember and it won't even be, the same people won't even be here. That's a great point and good practical guidance for our physicians and their workforce. So just moving on, we just had a conversation recently with Dr. Zeke Emanuel about the Affordable Care Act and whether the change in administration, what we can expect. And there was just something I wanted to ask here is when the administration changes, how does that change things in the U.S. Attorney's Office? Is there a priority setting or is it just business as usual? Should we expect to see a change?
Well, it depends. Obviously, ongoing investigations that are open and running long keep going. And every administration usually does try to put their own thumbprint on whatever particular priorities are. But usually over time, those priorities are not that different. Maybe the emphasis on a particular area is a little more in some venue. For example, the acting Attorney General for the Civil Division, and this was even before Merrick Garland became Attorney General, set forth a bunch of priorities in the healthcare fraud arena. And I can list some of these, and it's really not too much different from what you would expect. His number one was pandemic fraud. And okay, we know that that's being hit as a priority. The opioid problem, 81,000 deaths in 1 year, and it's continuing to rise. This has been a priority, and I think will continue. Elder fraud was another area he mentioned. That's been a DOJ civil priority for many years now, and particularly for Medicare patients that, in the home health area and others, it's been a major priority for some time. Another one, misuse of electronic health records and HIPAA, which again, that's been a priority. Telehealth, as Lisa mentioned, this is going to be obviously something on everybody's radar screen because until the pandemic, telehealth was really not an issue for Medicare, and it sure is now. So that's another one. And then, of course, the cybersecurity issue, which I think is on everybody's radar screen these days. So even though these were outlined in a speech that an acting Attorney General for the Civil Division gave several months ago, I don't think that that's going to change under the current administration. And many of these things have been carryovers. I mean, we've had a joint criminal civil opioid task force in Chicago for several years now. And so that's going to continue until we think the problem is under control, which may take a while. So at least for us, as they call it, out in the field, which means those of us who are beyond the Beltway and not in Washington, D.C., most of the time the change in administration is kind of like a ripple on the pond. We will probably get a new U.S. attorney at some point, but I mean, I can't begin to tell you how many U.S. attorneys I've been through over the decades in Republican and Democratic administrations, and it does not have an effect substantially on what we do as law enforcement and what we do in this area.
Got it. That is so interesting to know because it's been kind of a crazy few years and I just didn't know. And now one thing I was just going to ask you based on what you said is what is an example of elder fraud? Is elder fraud you took a person's money?
No, a lot of it has to do with exploitation of elderly, perhaps in nursing homes, using them, for example, saying that they need psychiatric help and having a psychiatrist go in and supposedly give them therapy when they have dementia and there is no way that therapy would be of any value. Billing for home health visits that the patient doesn't need. What Lisa mentioned earlier about the issues with durable medical equipment. Delivering stuff. We've had cases where people would have bottles of oxygen in their garage and they had no idea why they were being delivered to their house. Again, it's using their Medicare number and then billing under that number and using all kinds of schemes at these so-called health fairs and asking for your Medicare number and then running and using that and charging for things that they didn't need and didn't ask for.
Got it. Yes, I was thinking about when you were saying that those DME cases, which many times it was, like you said, things were just shipped to their home and they didn't even need it. And it was just like a massive scheme of shipping things to people. So that's very interesting. Thank you for sharing those priorities with us.
I'm going to jump in on one more that I just thought of only while Linda was talking, but it's something that I a million years ago would not have really focused on, and providers don't focus on it either. But at the ABA spring meeting for the antitrust division, one of the priorities for DOJ antitrust, so completely different than what Linda works on, but is antitrust violations in the healthcare space. And, this is public, but we represented Florida Cancer Specialists, who is now under a deferred prosecution agreement for straight up market allocation. And, I think there are a lot of providers who don't know and don't appreciate what is an anti-competitive role that they might recommend for their practice group, for their physician practice group. And when you're competing against other groups, you cannot enter into any agreement whatsoever with your competitors, but people do it all the time. And in healthcare, I think, frankly, it's been prevalent for years and years and years. And the spring meeting featured the new acting head of DOJ, who said what his predecessor said and what his predecessor said, which is healthcare is the next bastion of antitrust prosecutions. And so I really think people have to be really careful of what they do in that context. The other thing I'll say is the antitrust division had no clue what it meant to be excluded from a federal healthcare benefit program. So the first time we sat down with them and said, so you can't indict our client because you won't be able to cure cancer in the state of Florida. They were like, why not? We don't understand. I mean, we were able to sort of get to a resolution that was a win-win for everybody and under bad circumstances, but they're still building the plane while it's in the air. But it's going to happen. It's going to happen big, and it's going to happen for a long time.
Yeah, and it's so focused on providers, which I think is fair. But a lot of the market things that happen is happening with payers as well. And so that would be, they don't call me to get ideas. So anyway, I think this has just been so wonderful and helpful. I'm so thankful to both of you for coming and just sharing your view and your insight with us. I hope that you all will come back sometime and check in with us as things change and evolve. But thank you both very much for spending the time with us today.
You're very welcome. Thank you for the opportunity.
Thank you to our sponsor, Village MD. We hope you will join us for future concise compliance conversations.